When's a police officer not a police officer? When he's not executing a lawful duty. But when's a police officer not executing a legal duty? Let's talk about it. Hey, this is Alex Zouzlas, author of the book Courtroom Confidential, and I'm putting your brain on law. Just a reminder, I'm not giving legal advice, just telling you how I handled the question, is someone guilty of trespass and resisting where the police aren't executing a lawful duty? If you're an attorney and you need help with research and writing, hire me. And if you're a top-tier attorney looking to connect with a premier law firm anywhere in the United States, I can help you. My contact information is in the description to this video. In today's case, the defendant, Mr. D, was charged with trespass, disorderly conduct, and resisting an officer with and without violence. I prepared a motion to dismiss the charges. Here's how I approached it. Let's talk about the facts first. Mr. D was a customer at a Wawa convenience store. Because he was highly intoxicated, he was staggering and stumbling over display items and talking nonsensically. He tried to pay for candy and ice cream he'd eaten in the store, but the crumpled dollar bill and assorted coins he dropped on the counter wasn't enough to pay his bill. When the store manager, Sweezy Q, told Mr. D that he still owed money, he just, in her words, stood there for a while, staring at the money, confused about what was going on. Then he just wandered off into the men's room, licking melted ice cream off of his arm, end quote. Mr. D never refused to pay for the food he'd eaten. He never tried to leave the store, and Sweezy didn't tell him to leave. Instead, she called the police. She told Deputy Nova that Mr. D had caused a disturbance at the checkout counter and that she thought he was still in the men's bathroom. Deputy Nova noticed candy and other snacks lying all over the checkout aisle in front of the cash register. When he found Mr. D in the men's room, he asked him if he'd paid for the food he'd eaten. Mr. D said he thought he had. Deputy Nova then told him he was detaining him for trespassing and shoplifting, even though no one with Wawa told him he was trespassing. He hadn't refused to pay for the ice cream and candy, and he didn't try to leave the store without paying. Mr. D tried to push past Deputy Nova, who grabbed him and told him to stop resisting. Mr. D then tried to pull away from Deputy Nova. Both of them lost their balance, they fell, and spilled out into the hallway. Deputy Nova ended up sitting on top of Mr. D, who spun, twisted, and tried to push himself off the ground. Another deputy who'd arrived at the Wawa, Charlie Howe, tased Mr. D 3 times, causing Mr. D to, in his words, flop or hound. Mr. D was handcuffed, arrested, and then issued a trespass warning. A search of Mr. D showed that he wasn't concealing anything from the store, didn't have drugs on him, didn't have a weapon or anything else illegal. He also had enough money on him to pay for the food he'd eaten. So let's take a look at the argument I made on the resisting without violence charge. Florida Statute Section 843.02 says you're guilty of obstruction/resisting without violence where you oppose a police officer who's performing a lawful duty. When are the police performing lawful duty? And were they performing lawful duty here? No, they weren't. Surprised? Let me explain the argument I made. Where the police are acting as an agent for a property owner, they're not executing a lawful duty. The key to resolving this case, then, was understanding the purpose of Deputy Nova's responding to the 911 call and his capacity when he arrived at the Wawa. When issuing a trespass warning, an officer acts merely as an agent of the property or business owner. An officer's agreement to convey a business owner's trespass warning to a customer doesn't convert the officer's action into a legal duty. The police are still acting as an agent for the property owner. Moreover, until an officer asks a person to leave and the person refuses, the person is entitled to refused to identify her or himself because an officer doesn't need to know a person's name in order to ask them to leave property. A detention for the purpose of issuing a trespass warning on behalf of a business owner is a consensual encounter. Officers have no statutory or other lawful authority permitting them to detain someone for the purpose of issuing a trespass warning where, at the time of the detention, there's no reasonable suspicion that the person committed the crime of trespass or any other crime. Remember, where a customer enters an open business, they're presumed to have entered with the business owner's permission. In legal terms, they're an invitee of the business. In order to commit a trespass, a person has to refuse to leave after they're first told to do so by the business. Until that happens, the police aren't executing any lawful duty as law enforcement officers, and the person can simply walk away from the police, even where the person knows the police are attempting to detain them. Prior to his being detained by Deputy Nova, Mr. D was an invitee of the Wawa. There wasn't an existing trespass warning against him from the Wawa. The store manager, Sweezy Q, hadn't told him to leave. He hadn't refused to pay for the food, and he didn't try to leave the store without paying. Even if Mr. D had committed a trespass inside the Wawa before Deputy Nova arrived, the deputy couldn't arrest Mr. D because the trespass wasn't committed in the officer's presence. A law enforcement officer may not make a warrantless arrest for a misdemeanor, such as a trespass, unless every element of the crime is committed in his presence. Consequently, Deputy Nova couldn't place Mr. D under arrest for trespass. Instead, the most he could do was issue a trespass warning, and in that capacity, he was merely acting as an agent for the convenience store rather than lawfully executing a legal duty as a police officer. Since Deputy Nova wasn't executing a legal duty, Mr. D didn't violate the resisting without statute. But what about shoplifting? Was Deputy Nova investigating a shoplifting? The answer is no. When he arrived at the Wawa, it was clear to Deputy Nova that Mr. D hadn't shoplifted. He tried to pay for the ice cream and candy he'd eaten, and though he hadn't made full payment, he hadn't refused to pay the balance of his bill. He hadn't left or attempted to leave the store without paying. He was clearly too intoxicated to understand he hadn't fully paid. Sweezy Q didn't see him try to conceal any items from the store, and she didn't tell Deputy Nova that Mr. D had stolen anything. Since there was no evidence Mr. D had shoplifted, Deputy Nova had no cause to detain D, and since there was no reason to detain D, he couldn't have violated the resisting without statute. Did D breach the peace? Though Sweezy told Deputy Nova that Mr. D had caused a disturbance at the checkout counter, there was no evidence that Mr. D had engaged in a breach of the peace or disorderly conduct because the relevant statute criminalizes only acts which, quote, corrupt the public morals or outrage the sense of public decency or affect the peace and quiet of persons, other than police officers, who may witness them or engages in brawling or fighting. That's Florida Statute Section 877.03. Moreover, Deputy Nova hadn't seen Mr. D cause a breach of peace. Absent such conduct, a person isn't guilty of disorderly conduct. In order to prove disorderly conduct based on words alone, the state must show that the words either caused a crowd to gather, thereby resulting in safety concerns, or that the words incited a crowd to go nuts and engage in an immediate breach of the peace. While evidence of fighting or the defendants instigating a gathering, which do constitute a breach of peace, hand gestures, and aggressive behavior such as screaming and cursing alone, without there being anyone other than the police around, don't constitute disorderly conduct. There was no evidence that D did anything other than talk nonsensically and stagger and stumble around before the police arrived. No matter how hard you try to split hairs, that's not disorderly conduct. After Deputy Nova arrived, D didn't do anything other than brush past him, which he had the right to because there wasn't evidence he'd committed a crime. Deputy Nova and Mr. D fell because they both lost their balance when Deputy Nova, without any lawful reason to do so, grabbed D. Losing your balance isn't disorderly conduct. Therefore, Deputy Nova didn't have a reasonable suspicion that Mr. D was committing the offense of disorderly conduct. Consequently, relative to Mr. D's causing a so-called disturbance, Deputy Nova wasn't engaged in the lawful execution of a legal duty when he confronted and detained Mr. D. At most then, Deputy Nova was at the Wawa to issue a trespass warning on behalf of Wawa, which doesn't constitute the execution of a lawful duty. Since Deputy Nova wasn't executing a lawful duty, and there was no evidence that Mr. D had committed any crime, Deputy Nova couldn't detain Mr. D. Accordingly, Mr. D had every right to attempt to brush past and walk away from Deputy Nova. That being the case, Mr. D could not be convicted of obstructing the police. There's more. Not much more, but there's more. In addition to the police not executing a lawful duty when they confronted Mr. D's actions didn't constitute violence. Therefore, Mr. D couldn't be convicted of resisting with violence. Let's take a closer look at that argument. Florida Statute Section 843.01 states in relevant part that whoever knowingly and willfully resists or obstructs or opposes any officer in the lawful execution of any legal duty by offering or doing violence to the person of such officer or legally authorized person is guilty of a felony of the third degree. A conviction for resisting an officer with violence requires proof that the officer was engaged in the performance of a lawful duty when the resisting with violence occurred. In construing the lawful execution element of Section 843.01, courts must apply the legal standards governing the duty undertaken by the law enforcement officer at the point an act of violent resistance occurs. Moreover, the Florida jury instruction for resisting arrest with violence requires that the prosecution prove the police officer was engaged in the lawful execution of a legal duty as one of the elements of the crime. Because Deputy Nova wasn't executing a legal duty at the time he detained Mr. D couldn't be convicted of resisting the deputy with violence. Wawa's own security video showed that Mr. D was yelling, screaming, and allegedly refusing to put his arms behind his back only after Deputy Nova unlawfully detained him. The initial encounter between Deputy Nova and Mr. D was consensual, which means Mr. D was free to walk away from Deputy Nova. His attempting to walk past Deputy Nova, even knowing of the deputy's intent to detain him, in turn, doesn't constitute resisting. The simple act of fleeing from officers without more, under Florida law, doesn't constitute resisting or obstructing an officer. Instead, someone is guilty of resisting or obstructing an officer by flight only if he flees while knowing of the officer's intent to detain him and if the officer is justified in detaining him. But what about the violence aspect? Resisting an officer with violence is not the type of offense that a person commits accidentally or negligently using physical force. In fact, no Florida court has held in a published opinion that the use of accidental or negligent force is sufficient to support a conviction for resisting an officer with violence. To the contrary, the offense requires the intentional use of force. A defendant who acts negligently or accidentally is therefore not guilty of resisting an officer with violence. Doing things during the course of an apprehension that are capable of causing pain or injury to a police officer constitutes resisting with violence as long as the person intended the actions to do that. Kicking, flailing, throwing elbows or punches, pushing a police officer hard enough so that the officer takes a step back is resisting with violence intentionally, and where the violence is or could be sufficient to harm the officer. For those offenses that involve only a threat to do violence, Florida courts have interpreted the statute to require that the offender has the capacity to follow through on the threat to commit violence. D's actions, after he fell and Deputy Nova sat on top of him, didn't constitute violence toward Deputy Nova. He didn't take any action remotely indicating an intent to harm Deputy Nova. Video of the incident showed that Mr. D was face down on the ground calling for help. Though he didn't put his arms behind his back until he'd been tased 3 times, he never struggled with Deputy Nova. Mr. D's legs moved while Deputy Nova had him pinned to the ground, but he never kicked or attempted to kick the deputy. Mr. D didn't try to punch, bite, spit at, grab, or commit any other act of violence toward Deputy Nova. And the only time he squirmed and twisted was when his body was involuntarily reacting to the massive electricity that passed through his body when Deputy Howe tased him 3 times. Furthermore, Mr. D never made any verbal threats of violence toward the police, which could support the notion that he was trying to hurt the deputies. Since none of Mr. D's actions could have hurt any of the deputies, and his actions didn't indicate an intent to harm, there was no proof supporting the charge of resisting with violence. Consequently, the charge of resisting with violence had to be dismissed. Let me know what your thoughts are on this very interesting issue. Thanks for watching, and I'll see you next time.